with this and trying this out. Um, so so yeah, forgive us for glitches in technology or other things that way, but we're hopeful that this will be helpful for everyone. Um, I'm Josh Freeman. I am one of the founding partners of Freeman Lovell. We are a firm that focuses on helping entrepreneurs and small businesses um, take their ideas and turn them into scalable businesses. And um, this is just a wild and exciting time. Something that none of us have ever experienced, and it's been a wild ride to see all of the things, the responses in government and everything going on. I asked my partner, Mike Thomas, to join me on this webinar today. Mike has a background that he'll share with you guys in a minute, but he spent a lot of time dealing with resolving disputes and and advising businesses and clients on how to deal with a lot of these new situations and issues that we're facing. And so I'm excited to have him, and I'll have Mike now give a little introduction for himself.
Thanks, Josh. Yeah, as Josh mentioned, my background is largely in dispute resolution. What I've learned from seeing a lot of lawsuits and a lot of fights and a lot of dysfunctional legal relationships is there are things that people could have done on the front end to help resolve those things. And so my practice has been transitioning more and more into helping provide advice and good documentation on the front end. And also, as Josh mentioned, the issues are changing before our eyes. The things that people care about, the novel things that are coming up and disrupting relationships. And as we all try to continue business in a new world and get back to business in the ways that we can, new challenges will continue to present themselves. So we saw this as an opportunity to share some of the things that we had been observing and figuring out along the way, along with everybody else, in terms of helping to heal the harm caused to legal relationships as a result of the pandemic and the consequences from COVID-19. So are we ready to jump into some issues, Josh?
Yeah, I was gonna say a lot's happened over the last just the last couple of days, especially here in Utah. So Mike, do you want to bring us kind of up to speed with what we know and the things that Utah's legislature is doing to prepare businesses to go back to work, and maybe some other things you've seen around the country?
Yeah, certainly. So there are different types of relationships that have been impacted. Landlords and tenants, certainly, employers and employees, service providers and their clients who are under contracts, and even just like venues, businesses where people are used to coming and their customers. So those venues and people associated with brick and mortar establishments, we're starting to get concerned about liability, whether they by opening their doors were going to open themselves up, exposed to claims of negligence. If, say, you're running a restaurant or a store or a salon, and a person in the chair next to you is carrying COVID-19 and you contract it, question becomes, well, shouldn't that business owner have done something to help keep me safe? And do I have a claim for negligence as a result of that? So Utah is fairly ahead of the game in addressing this particular concern. There may be we're Utah based. I think a lot of our initial attendees today have interest in Utah, but other states may be following suit or could follow suit. There is a bill 3007, that just in the last day or two, the Utah legislature has voted to approve. And it's essentially immunity from negligence claims for exposure to COVID-19 on a business's premises.
And Mike, do you know how broad this extends to? Is it just certain types of businesses at this point, or is it super broad brush? I haven't read the bill yet.
Yeah, I read through the bill. The bill is surprisingly short and easy to get a handle on. It defines business premises, which I think would be open to all of those examples that I mentioned. Uh, it, Museum, salon, restaurant, anywhere that people um, come to do business with you or to enjoy the services that you provide, it would apply to that. And so it's not full immunity to every situation. Let's say you have COVID-19, or you know that an employee does, and you like rub your face all over the door handle or something absurd like that. You know, for instances of willful misconduct, reckless infliction of harm, or intentional infliction of harm to others or the public, no, you're not going to get immunity for that. But the idea is Utah wants to see people be open for business, and to not put the risk of contraction between and among members of the public on those premises owners.
Hmm.
So that raises some questions, right? Like, do they need to warn everybody that's coming in? You got to put a sign on the door with the disclaimer. That was one question that came up in the debate with the legislature, and they decided no, that would be kind of counterintuitive and defeat the purpose if you're scaring people away from businesses. And it's kind of this return to people managing their own risks, taking the precautions that they see as necessary, and not making business owners and premises owners bear the burden of transmission among their customers. So,
Okay. Do you know? So if I were to call an all partner meeting and require everybody to appear in person, and unbeknownst to me or anyone, someone's a carrier of COVID-19, does does this immunity apply to like employee claims against a business if you're getting people back in the same room, working on projects together? Or is this really just applicable to a restaurant or a business that's open to the public and for contraction between public, users of their venue?
well, this particular statute, which I should mention, hasn't is now going to the governor of Utah, and so although chances of it being enacted are good, we're at that phase of it. But yeah, it's really focused more on the premises liability, and so with separate gatherings, like if a boss, employer, supervisor were to gather people, then that would be governed more by other existing statutes and regimes. From common sense to, if you're a business that's governed by OSHA, then OSHA rules would apply and that type of thing. But this particular statute doesn't address that situation.
Okay, so going back to this, so the legislature passed the bill, and now it's on the governor's desk to sign. And the question is whether the governor is going to sign or veto. Have you seen any indication of either way on that?
No, this is fairly recent, so
Okay.
I'm not sure one way or the other.
Yeah.
Um,
I understand there was a bit of debate about, on this law of whether, you know, it's going to result in allowing businesses to be somewhat reckless in how they, open up, and that, you know, they're not going to need to be as careful about cleanliness and other issues like that. I- is there anything in the bill that addresses those kinds of things? Does that come up with kind of the reckless issue you're talking about? I mean, if I, you know, if I own a business and I'm having clients come into my business, what what should I be doing in anticipation, you know, of these kinds of issues?
Right. Well, I would come back to, business decision making being against the backdrop of several layers of considerations. And you've got you've got statutes and regulations, you've got local ordinances, and you've got contractual obligations. You've got maybe your own business and company policies that bind you. And then you start to get into just business judgment considerations, and then even one step beyond that, public perception considerations. So, along this continuum of what influences your decision making, I see that in these public spaces, what Utah is trying to do is to maybe lower the bar on what is going to get you exposed to a negligence claim.
Hmm.
But as far as making customers and employees feel comfortable in your space, you're going to have to do more than the bare minimum. I think of, the governor's in Utah is telling us to do takeout to help the economy in the restaurant industry. And I can think of two separate instances. One where we went through a drive-through window, and I couldn't tell if there was anything different going on at that particular drive-through window, and I was not encouraged to go back. I went to a different place, and you've got people, employees in masks, and they've got protocols for keeping vehicles a certain amount of space apart, and they bring the food out to a table in front of the building, and you've prepaid. And that's the type of thing where I'm more willing to go back. We've got a kid with asthma at home and a more sensitive situation, and I personally appreciate something like that.
Hmm.
Essentially, it's not going to be a free for all because it's bad for business. It's also not going to be a free for all because, as you pointed out, if even with Utah's efforts to maybe lower the bar in terms of negligence claims, they don't remove the bar.
Uh-huh.
And our definition as a society and as judges go to apply these rules, our definition of what willful or reckless is going to be is going to adjust with information about COVID-19. Um, you know, so so yeah, I would tell a business owner to make the types of accommodations and adjustments that they would see their customer base feeling comfortable with, not only because it's good business, but because it's going to keep you away from those claims of willful or reckless actions in inviting people into your space.
Yeah. One thought that I've been kind of stewing on in this is, you know, they wanted to make sure that this law came out so that, you know, so that business owners felt comfortable reopening their doors. Part of me wonders if there may be an unintended consequence of, by granting this immunity, whether the public is going to have a lack in confidence in going back into those, you know, establishments and begin to do business more like they did before. I read something, I guess Germany has reopened a lot of their stores, but like no one's going in to shop or do those kinds of things. And so I don't know if there's any considerations that way you want to, you know, add on, Mike, but that's a thought that I've been wondering too, is balancing both. You know, it's like we got to make business owners, you know, comfortable and protected, open up, but we also got to make sure that the consumers are going to be willing to go back in and do business. And so I don't know. Any thoughts on that?
No, I mean, that's a totally valid point and probably a consequence of protecting the business owners will be some hesitancy on the part of customers to go back in. And that's where, being clear about what you're doing to protect your space, even above and beyond what might be regulated or in the ordinances or in the statutes, can be critical to helping people feel comfortable about coming back.
Awesome.
Um, so, that's one type of relationship that's affected. Um, then we've got tons of contracts that have been upended in various ways. Performance getting difficult for some people, less valuable for others. Um, and changing the circumstances a little bit. I'll throw out an example. You got a lot of people who were scheduled for their spring weddings, and if you were planning to throw a big wedding on, April 4th, then you would have run into some issues. And so you can imagine a scenario where you have a florist that has a contract to provide a bunch of flowers for the big event, and a highly reduced interest in attendance, maybe arguably not even possible to put on a big wedding without like precautions that make things that sucks the fun right out of the event. And so people changing plans and adjusting and doing smaller affairs or moving back dates for weddings. So what do you do with a contract to provide flowers on April 4th when maybe flowers aren't going to be the same months and months later, or you're ready to go and your client isn't? Um, we get situations like this coming to us quite a bit right now. Not just that exact situation, but a lot of situations where performing on a contract is difficult. So uh, one of the contract provisions that I would say is having kind of its moment right now is the force majeure. Is that how you say it, Josh?
That's how I say it. Yeah, force majeure. I don't know if it's right. It's probably wrong, but yeah, yeah.
Uh, Force majeure, and what does force majeure mean to you?
So I actually, so this has been a really interesting thing. I just got an email from a client on this right now who had planned a big retreat for his company, and and he was smart enough that when he was doing this back in December, he was seeing what was going on, and it's overseas, and he's in the actual contract, he built in language in the force majeure clause that addresses a pandemic. And so what generally a force majeure clause is it, the idea is if a contract becomes un you know it becomes disrupted by some unforeseeable event, a lot of times referred to by acts of God, whether it's a disaster or war or terror or something like that that comes up that, so changes the game and was so out of the anticipated course of events that parties should be kind of released from their obligations. And so yeah, so and typically you see, like earthquake, disaster, you see, war, terror, other things like that. And some contracts have, had language about pandemics and other things like that, come up. But it's a provision to help that. We've seen it come up also in the landlord tenant space, or similar provisions for catastrophic type events. And right now there's a big argument of, how do we interpret that? Does a global event like this pandemic release someone from the obligations in a contract just because they are generally affected as a member of the general public suffering through, this global pandemic? Or is it something where it needs to specifically impact, the area of performance, or the actual individuals or parties to the contract? And so that's an interesting area where that's starting to get litigated and disputed, and having some legal tensions arise between, parties to a contract, of whether or not this clause lets them out. And so that's one of the kind of interesting areas that we're dealing with now. What Another area where we see it a lot is in commercial leases. Some commercial leases will have force majeure clauses in them. And so the question comes up, like, what does that mean for me? Does that mean I get out of my lease, or, or that? And, and the challenge is, especially with commercial leases, typically they've been used in ways to justify the failure of a tenant to occupy a premises, but it doesn't give an excuse for payment. And so even if you do have a force majeure clause in a contract, or someone's raising that as a reason to get out of a contract, you have to carefully look at what the provision is, what it means, how it's actually impacting the parties in the performance, and other things that way. So it's it's an interesting issue, but it's not a get out of jail free card by any means.
Yeah, absolutely. I think your last comment is spot on. Is you've got people who may be thinking to themselves, well, force majeure clause in the contract means something crazy you didn't see happening happens, everybody's off the hook. But it's definitely more nuanced than that. Courts have interpreted these force majeure clauses very narrowly. And also, you have to look at the details. They're not all written in the same way. They are designed to allocate risk in the event of an unforeseen catastrophe, but in different ways. So yeah, exactly like Josh pointed out. I mean, you may still be left with an obligation to pay or to forfeit a deposit, or something along those lines, because that's what the contract anticipated. What I've been thinking about recently with the force majeure clauses, kind of going back to, I did a clerkship with a judge where I worked behind the scenes helping a judge to make decisions on cases. So kind of putting on that hat, I've been thinking about what I would do with some of these force majeure situations. And it seems like our judges ought to, or likely will, view them not like one off at a time. Okay, so go back to my example of the flowers for a wedding. If you've got a force majeure clause there, and it says that if there's an unforeseen act of God, then performance is not required. Well, there's still plenty of room to say that someone might still need to pay for those flowers, because was it unforeseen that a wedding could be canceled, that someone could get sick, that if it were outdoors, it could get rained out? It's not completely or unforeseen for a wedding to be canceled. Is it unforeseen for a global pandemic called COVID-19 to swoop in and result in massive shutdowns and social distancing? Maybe with that level of specificity, you're unforeseeable. But to treat it like that, nothing would ever be foreseeable, because you can't tell the future. So I think the analysis is going to get much more into whether the circumstances and consequences of COVID-19 are foreseeable in some way or another, rather than whether the specific disease and level of pandemic was foreseeable. But any other thoughts on that, Josh?
No, we actually got kind of a good little comment here. Maybe it's kind of stepping maybe back and forward a little bit. But talking about, you know, how as an employer to address, in-person meetings with employees and new hires, and this one asked about an internship, when a virtual meetings are great and can do a lot of things, but there is a time and a place and a need for, being in person. um since it doesn't look like an employer is going to have, immunity if, they say, hey, we've got a new hire, we want to bring everybody in, meet in person. What kind of precautions should be taken, or should they just not do in-person meetings at all, even though, legally you're, we're back in business and, that sort of a thing? What kind of, like, advice would you give, an employer thinking about those, and how do you address that and think that through?
Yeah, so taking it case by case, different workplaces are going to have different concerns. Some are going to be at higher risk than others, and the nature of interactions are going to be different. But I would be sending clients to, or encouraging them to look at OSHA standards as a starting place. OSHA prepared a publication recently entitled Guidance on Preparing Workplaces for COVID-19 and Testing Our Technology. Here, let's see. Boom. Okay, link provided in the chat box. And so taking things case by case, it looks like like if you've got a group that is going to do office type things, computer type things, and there's no real tangible benefit to meeting together. And we're still in a place as a society, and what we're being told by the authorities, that transmission is a risk, that social distancing is important. Yeah, I think you move those online, because if someone contracts something at a meeting like that, you're going to be looking back and saying it would have been reasonable to do that online. If there are certain tangible benefits to meeting in person, and you've got a group of employees who are able to meet together and observe certain safety protocols and precautions, and still do it, then I think you could go for it, and that you would be protected by your efforts at reasonableness and by checking with existing regulations before you do it. I can appreciate a little bit of wishy-washiness to that answer, but that's because it's tough. It's a moving target. It's this when you take a standard like reasonableness, it develops based on circumstances and the nature of your business, and how risky the population is on one axis, and the information we're getting about what to do to stay safe on another axis. And you've got to find that sweet spot of acting reasonably.
Oh, hey, Mike, your link just went to the panelists, I think. So if you could resend that link out to all participants, so attendees as well. Yeah, so what, maybe buy hand sanitizer, keep that in there, require masks to be worn, get some Lysol wipes and spray and stuff, and send a memo around to everybody to clean their keyboard daily, and and that sort of a thing is, I mean, as far as like
desks further apart, chairs further apart, those types of things. And then a certain level of common sense too. If you've got people coughing, you don't include them in the group in-person discussions, and that type of thing. But yeah, like I said, it's the risk associated with your group versus the information that will continue to develop. Um, but I haven't dug that deep into the OSHA guidelines to get into specifics. Um, and I'm confident that it depends on the types of workplaces.
Yeah.
But for example, our law firm, like I think you'd probably agree, like we should not sit in a circle holding hands together tomorrow. Um, if we got each other sick, I don't think anyone would look at that as acting reasonable because
Right.
we can do a lot of what we do
Yeah.
online.
Yeah. What what about the situations where your employees like, hey, I'm in a small apartment, I've got 2 kids, I can't work here anymore. I need to come back into the office, that sort of a thing. You suggest, implementing some forms of policies and things with regards to cleanliness, checking temperature. I mean, what kind of things as as an employer would you do to try to limit the issue of those people who really do want to get back face to face and that. Yeah, what do you think that way, Mike?
Yeah, I mean, going back to the things we're hearing a lot about right now, setting up desk spaces far enough apart, doing regular sanitation and walkthroughs, air filtration systems, um, scrubbing the things that come in and out if you have certain instruments or packaging or things like that as you go. And really, at the end of the day, it's going to be a question of acting reasonable. I can't pretend to be an epidemiologist on some of these issues, but certainly,
Well, you could pretend.
yeah, I could pretend. Now would be a good time to explain that this webinar is presented for informational purposes and cannot be used to hold us accountable for epidemiology issues.
Right. 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 Um, there's been a lot of talk about like the different stimulus packages and the PPP loans and different things like that, and we've discussed those and done some other things and provided some articles on that. One of the areas that was initially a big hot topic was the FFCRA, which has to do with enhanced leave policies and other things like that for employers and everything like that. I understand those, the effectiveness from that runs through the end of the year currently. What kind of things as an employer do we need to keep at the top of our mind, since that's been kind of relegated under a lot of the stimulus package conversation lately? What are some things we should be thinking about in that direction?
Yeah, when these things first started to be enacted, the end of March, um, the effective date was pushed out to April 1st. We're past that now. Where those laws are in place. The FFCRA, um, which stands for Families First Coronavirus Response Act, is basically designed to provide leave to people who are in one of two categories. You've got those who are sick or symptomatic or quarantined, and then you've got people who are forced home with kids whose schools or daycares are closed. Um, and the statutes included in this act basically provide leave for these groups. And we've, like Josh said, we've gone into detail on these in some of our articles, and the requirements are pretty easy to find online. But there are a few updates that I think are worth mentioning. Since the law was first enacted, we've gotten some regulations in place. So your statutes are going to say what the law is. The regulations tend to get into a little bit more detail on the how. And the regulations for the FFCRA came out. By now, employers should have their notices up in a conspicuous place in the workplace, similar to what you'd see for like minimum wage standards. That type of poster is available. The question that been getting a lot is about the small business exemption. All right, so if you have fewer than 50 employees, then you can make the argument that it doesn't apply, and not just by virtue of your size alone, but it's a combination of your small size and your vulnerability. And here's what I mean by that. There are essentially three ways under the regulation provided in the Federal Register that you could qualify for the exemption. One is if providing leave for these groups, paying them to not come to work, would result in the small business's expenses and financial obligations exceeding available revenues and cause the small business to cease operating even at a minimal capacity. Okay, so if you can't keep up, you're underwater because you're paying people who are not doing work and helping to generate revenue, that's one way you qualify. Another is if the absence of that employee would entail a substantial risk of the financial, health, or operational capabilities because of that person's specialized skill or knowledge of the business or the nature of their responsibilities. So if you've got a small business and you've got certain people who are indispensable, that linchpin, cornerstone, that type of person who's without them, you're not functioning and staying profitable, they can also be excused from performance for that. And then there's our third category, which is kind of what I think of as the cumulative effect. If you're in a workplace where a lot of people are being impacted by these leave requirements, and so there are not sufficient workers able and willing and qualified to be there and to do the job and keep you operating at a minimal capacity, then there again, through your combination of size and vulnerability, you can qualify for an exemption to the paid leave requirements. What's interesting about that is, kind of drawing on the tax system, which at least starts out as an honor system of sorts until there's enforcement or an audit or something along those lines. They're approaching this in the same way. It's some sort of application process would not be feasible. They don't have the resources to do that. So you can't apply for the small business exemption to these requirements. Instead, the decision makers, whether it's a manager, president, board, what have you, within the organization, are expected to make careful decisions, decide if the exemption applies, and document it, and save that documentation for 4 years. And so that you can respond to concerns or challenges or claims that may arise later. So bit of an honor system, but if you're going to claim that exemption and deny leave requests, you should keep the leave request. You should be able to show that you had the notice up, and you should be able to document that based on one or more of these circumstances, you were a vulnerable small business and in a position to deny the leave.
Interesting. So how do you think that plays out? A lot of lawsuits down the road for these smaller employers?
It'll depend a lot in how they handle it. I mean, your employment is such an important part of your life and who you are and how you support yourself. But I would think that for a lot of employer-employee relationships that are built on trust and good education on the issues and understanding, if you complied with the requirements, then you would probably met with a certain level of understanding. But if you go in and you've got 12 employees and 6 of them are moms who have kids home at school, and you just fire them and keep everybody else, and like with no further
Yeah.
analysis on the issues because you don't want to pay leave to those people. Like this is going to become a new grounds for discrimination and claims of retaliation. Uh, it's built into the system for the FMLA, and
Hmm.
in the same way that you couldn't fire someone for being pregnant or having a kid,
Hmm.
you can't. You're not going to be able to fire someone just because they qualify for this leave.
Okay.
So that the documentation, the analysis, the putting thought into it, and is going to be imperative to avoiding claims and being a decent human.
So it'd probably be wise if you're, if you're an employer, to wherever you keep your notice published in your break room, to go take like a timestamp photograph of it, like now before those claims happen, to keep in your files. And
It wouldn't hurt to make that a part of the documentation. In addition to whatever accounting records you might have that can show that minus this person, your business is legitimately at risk, or minus all of these people involved, your business is legitimately at risk. Doing things to show that you were complying with notice requirements and just doing reasonable things and sitting down and looking at how your business functions
mhm,
and I mean setting aside the FMLA and FFCRA leave requirements. I mean just making your business decisions based on function and role if you're going to do layoffs rather than picking on people who need leave is and documenting that is going to keep you out of trouble. Should mention in terms of staying out of trouble, like the your risks. Josh pointed to one of the risks, which is just you could get a suit for discrimination. An employee who does not who has a bad experience with you and feels discriminated against could bring a claim for discrimination under the act. There's also enforcement measures that have been implemented in the regulations by the Department of Labor. They're treating it basically the same as and tying the remedy to your minimum wage um, regime and statutes there. So you would face the same type of penalties for denying leave that someone was entitled to that you would for paying someone less than minimum wage, which
mhm,
involves fines of $1,000 per violation and more severe penalties if it was found to be willful. Like you
mhm.
did your research, you knew you weren't supposed to do it, you put up a notice, and then you just started firing people because they had coronavirus with no further analysis. Like that
Yeah,
type of thing
not
could
good.
no problem, not great.
Not great. Okay, another question on that one. Um, so with the schools being closed and everything like that, there was essentially leave requirements granted to the caregivers for those children. With different school systems and things like that shortening their school period, the length of time that the school is going to be um, in session, I guess. Like our school district just shortened the school year by 2 or 3 weeks or something like that. Does does that um, grant of leave disappear when school ends, or how does that play out with requiring to provide a certain amount of leave for caretakers for children that have been forced out of school?
Yeah, so it's a 12-week leave requirement, up to 12 weeks, as long as you can continue to show that you qualify by virtue of having kids to take care of and not the school or the daycare situation that you were expecting. And I don't know that I have a ready response on that. I've been wondering the same thing in terms of the of parents who must have had some sort of plan for the summer in place, right? And
Mhm.
so, and when kids are out of school for the summer, I think you could make the argument that if you were planning for your kid to spend the first 6 weeks of this qualifying period in school, and then starting up in the summer, you are going to have a babysitter in place, or a daycare situation, or summer camps, or whatever the game plan was for the summer. If that's been eradicated too, I would see that still qualifying to extend the period up to the
Up
12
to,
weeks. You know,
okay.
it's not endless leave. And I have to think that the policy behind it is to buy parents time, not to be like a permanent fix, but I see it as buying parents time to figure out what they're gonna do. In terms of uh, operating and doing their job in under the circumstances. I
Yeah,
don't know,
that makes,
anything you would add to that?
no, that makes sense. Yeah, that those are just kind of some of the open-ended issues and questions that we're going to deal with. Um, I want to kind of open this up, that if any of the attendees have any questions, you can post it in the webinar chat, or you could also, there's a Q&A function in Zoom. So if you have questions or things you want to throw out now, that sounds good. And while you're starting to do that, I'll just throw out kind of one more situation that we're dealing with. In our practice, we represent and work with a number of landlords, and of those, a number of student housing providers. Um, you know, we talked about this immunity legislation that may or may not ultimately get signed into law. I don't know, Mike, do you think that's going to provide immunity for a landlord when a student signs a lease and they're sharing an apartment with a number of other students, and and typically the landlord chooses which students go into which apartments, and they sign up sometimes for shared rooms or private rooms or different things that way. How do you think, assuming laws like that get passed, how would that play in, and what kind of things can landlords be thinking about and doing to mitigate, risks of, lawsuits and claims and things that way from their tenants?
Right, yeah, that's an interesting and good case study on kind of the different levels of analysis involved with something like this, because someone comes to me with an office share or student housing where you've got people kind of in close quarters. I would start with the contract for sure, looking to see if there's some allocation of risk there. There's the force majeure clause. I'm wondering how much that really applies, because when you sign up for student housing, you expect to be with strangers who or with people that you know. In any case, from different uh, backgrounds that can come into a space, and you can't control what they're doing and how sick that they are, or what risks that they're taking. So I think force majeure is unlikely to apply. I think that you then look at your common law doctrines, which are what the courts do with contracts outside of their terms. Things like impossibility, whether the the landlord has whether it's impossible for them to provide the space. No, if you can still get in there, it's just a bigger problem than it was before, and riskier than it was before. I mean, isn't the landlord doing their part by providing the space? Was there a frustration of purpose? That's another common law doctrine that you would want to look into, which which considers the original purposes of the contract contemplated by the parties and asks whether these change in circumstances is an unforeseeable supervening event, and whether that has resulted in making the contract essentially useless to someone. Um, so you're going to go through that analysis, all right, and you're going to look at what's in the contract. You're going to look at what city ordinances or federal regulations might impact you, and then you're going to look at what a court might do with it under the circumstances.
Yeah.
And for landlords, I could see in order to improve their position, to help them be better situated for when these challenges to the lease come up. You want to do things and make offers and suggestions that move living in the space or working in the space from impossible to burdensome. Okay, now burdensome is still not great. You don't, I mean, it's not, you want in your legal relationships to have compliance be mutually beneficial as much as possible. But as far as your rights as a landlord and legal standing, taking those steps that make compliance or the using the space burdensome rather than impossible is going to make a big difference in the analysis. And here's what I mean. Like if someone can wear a mask and sanitize and stay 6 feet away from a roommate, and you've got things up in places, or 6 feet away from others in a shared office space, if you're doing your part to make functioning in the space at least possible, then when you go through the analysis of whether force majeure applies, whether the impossibility applies, whether the frustration of purpose applies, you're going to be in a much better position.
Yeah.
But there again, that's just the question of legal rights and responsibilities, which, as we talked about earlier in this presentation, that's your floor. Trying to find other ways to work with people, figuring out if deferrals are reasonable or practicable, if moving people in spaces, subleasing, like all of that ought to be in the table as you're troubleshooting. But at the end of the day, if you've got to put a foot down and enforce your right to collect rents against someone who's being unreasonable and unworkable, then taking steps to make things not impossible but just burdensome is going to.
Yeah, and I think like you were talking about is the contract's going to be, as far as that legal basis, a place where people are going to look. And with this new reality of COVID-19, it's going to be really important for, business owners, landlords, pretty much, all sorts, pretty much all businesses to revisit their contracts and probably add in provisions that address some of these issues. I wouldn't be surprised to see, like when you go skiing, on the back of your ski pass, when you buy it, essentially a waiver of the inherent risks of going skiing to limit your ability to sue them for getting injured there. I wouldn't be surprised if you start seeing those on menus in restaurants and things like that, of you waiving the risks associated with gathering in a public place and potentially getting a life-threatening, illness. Because now the risk of that happening is so much higher than it ever has been before in the past, and with landlords, addressing that in the lease agreements that, that address those issues, that discuss those things. I think, adopting employment policies associated with that when, employees choose to return to work, having language in there that, addresses the policy of the employer with regards to them, their workspace, choosing, where they work, how they work, addressing sanitary cleanliness issues, addressing coming into work when feeling ill or sick, and potentially waiving claims against the employer for those types of things. And, and all of that, there's the relationship and, politics side of making sure that those things don't, come across wrong with your, clients, tenants, employees, other things that way. But those types of things I think are going to become a lot more prevalent in the world. And that we had kind of one question asking about resources and other things like that. And right now we don't have a blog post on this, but we are in the process of preparing one based on what we've talked about today, and creating some resources for these kinds of things, as far as waivers, addressing leave requests, and doing different things like that. And so those are things that we're going to work on and have available to our community. Um, so I think that's all I got. Mike, any parting thoughts before we close out today?
Just that you're absolutely right that something like this will shape not only the statutes and regulations that the people in positions of lawmaking um, are going to do, but also down into case law. I'm confident that we're going to see judicial decisions about what constitutes discrimination under these new acts. We're going to see new case law in states about what impossibility means, what frustration of purpose entails. And it's going to be interesting to see how people react. I mean, when we had the HIV AIDS spread and concern, I mean, it trickled down into things like how the National Basketball Association would handle a timeout if someone started bleeding. Like, I think in similar ways, we're going to see policy and legal changes that match the societal changes in terms of scope and influence. So it'll be interesting to see. And in the meantime, we're available to help and answer questions. I just wanted to throw out there that couple of the things that we might be able to do to help include a contract review, and we're offering a 1 hour contract review at half of our hourly rate. For those who hear this and are interested, feel free to reach out. We're also offering mediation services at half the usual rate. If you find yourself in a dispute in one of these situations, one of the ways to get ahead of a lawsuit can be to get a neutral mediator involved to help with dispute resolution. And that's something we can do as well. But in any case, we hope that the information we provided gives you some ideas for how to address these concerns, and really appreciate the participants and anyone out there who stuck around to listen. So thank you.
Awesome. Yep. Thank you.